original, mighty the god, the magical radical. Hey, representing my magical. Young Jose, come milli, Jamaica, watcha. That deep star, can I teach me the Jamaica copa? That watcha, can I damage me the Jamaica watcha? That deep star, can I teach me the Jamaica copa?
Good morning, welcome to my YouTube channel. My name is David Okon. We are talking in the UK about work. Today we are looking at a component, a factor of employment claiming based on certain employment rights. We are specifically going to define a fixed term contract. A fixed term being actually a fixed term contract is being part of employment status in the United Kingdom. If you are watching from the United Kingdom or even watching from somewhere else, then employment law and policy in the United Kingdom is similar to what you find in the other countries. If you watch this video, watch alongside the rest of the video. Thank you so much, everybody who have been watching my videos, sharing with family and friends, and also clicking notification bell for new videos if they are posted, and also leaving a comment. It's good to have a conversation on this topic in the United Kingdom. What happens in the UK, as I said before, also happens elsewhere. So they are may not be the same, but quite similar in terms of structures, laws, and policy, and also practices. This is due to an economic system known as capitalism, which is global. Within the global system, there is cooperation between states and also harmonization, where one thing happening in one country also happens in another. So if you are interested, leave a comment below. If you need something specific, we are looking at the definition of a fixed term contract to know what they provide and what they might not be able to provide. And thank you so much. And from October of 2002, the definition of a fixed term contract under the Employment Rights Act 1996 is changed by the regulations. From that date, an employee is counted as being a fixed employee regardless of when their contract began. If they have either a contract of employment which is made in advance of it starting for specific length of time. So when we say employment contract, actually we're talking generally, but fixed term is part of the employment status in terms of contract. Contract can be compared and contrasted with statutory rights. These are contractual rights in terms of employment. These are actually technical materials, so leave a comment below and let me know your thoughts about how this system works. So a contract of employment which is made in advance, if it's starting for a specific length of time, therefore it must also include the date on which the contract is to end. The beginning and the end of the contract. So a contract of employment where the employee is contracted to do a particular task, which ends when that particular task has been completed. So the contract gives no actual date when it is the end, but sets the date of the contract ending as the date on which the task is completed. So this is how the material looks. So this type of fixed term contract is called a task contract. So let us look specifically at what a task contract is. So a task contract are contracts where the employee is contracted to carry out a particular task, such as the painting of a house or running a training course. They also include contracts of employment which end automatically upon the occurrence or non-occurrence of a particular event. For example, the contract which ends if there are sources of funding for the work are not renewed. So we're talking about situation involving a contract and funding. So contracts which terminate because the employee reaches retirement age, or which terminate because the employee breaches the contract through gross misconduct, which are not task oriented, is in having a situation of task contract situations, unless they are for a particular task. The ending of a task contract counts as a dismissal. So if that contract is ended, then you are dismissed. Statutory rights of fixed-term employees. In the opening of this video, we compare contractual rights or obligations in law being comparable with the statutory employment rights, specifically to this statutory right of fixed-term employees. Therefore, statutory employment rights are those given by law rather than those given under the employee's contract. When we talk about the law per se, we are talking about statutory source of primary legislation as being a primary law, as opposed to contractual obligations, which is a type of law, but for this purpose, the statutory law is regarded as law. So statutory rights law applies to all fixed-term employees regardless of when their fixed-term contract started. Statutory employment rights for fixed-term employees include a limit on hours of work for most employees, except, for example, domestic workers in private household. These are examples. As you can see in this dispensing, an entitlement to the national minimum wage for most employees, the right to not to be discriminated against because of age, disability, gender reassignment, marriage or civil partnership, pregnancy or maternity, race, religion or belief, sex or sexual orientation. These are categories specifically listed under these rights: parental paternity, adoption, maternity, and shared parental leave, with some exceptions. There are exceptions that are contrary to rules. So you have also the right not to be unfairly dismissed. In some cases, the employee will have to have worked for the same employer for a qualifying period. There's something called qualifying period. It used to be the case that fixed-term employment contracts could include a waiver clause whereby the employee gave up their rights to claim unfair dismissal. These waiver clauses have not applied for some time. There is also the right to notice of redundancy and statutory redundancy pay, provided the employee has worked for the same employer for 2 years. There are special rules for fixed-term employees where the fixed-term contract may have included a waiver clause which prevented the employee being entitled to statutory redundancy pay. There are circumstances also where the right not to have authorized deduction wages made from wages may apply under these conditions, and also the right to statutory sick pay and statutory maternity pay provided the employee fulfills the usual qualifications for entitlement. Let us also look at contractual rights of fixed-term employees. Contractual rights of fixed-term employee is comparable or contrastable to statutory equivalence, which is what we just looked at. We are continuing to look at the contractual equivalence of fixed-term employments for employees under these conditions. So under the regulations of fixed-term employees, we will have the same contractual rights as their permanent colleagues, unless the employer can show there are good reasons why this should not be the case. So you can see, in terms of regulations also relating to this contractual right, there are a slight difference, a watering down of rights in favor of employee, or actually in disfavor of employee under these circumstances where there is an element of discretion where the employer can, in certain circumstances, provide a reason for denying certain rights to its employee. That is actually a type of difference between statutory right and contractual right. Contractual right has to do more with providing more leverage or freedom or more right and power to the employer as opposed to a statutory equivalence. This in politics or in policy means the government intention in watering down employment law, giving more rights under contractual, because contract is actually agreement between employee and employer. They are given freedom to negotiate between them, the two. The state withdrawing its arms from employer or employee relationship, and giving more freedom to employer and to the industry to actually make decisions independently, more independently of the government. And this is actually an argument for a non-regulatory approach to industry and perhaps also, if you like, trade, as it is found in the employment. So let us see, under the regulation, all fixed-term employees will have the same contractual rights as their permanent colleagues. Remember, there is actually the difference between fixed-term and permanent colleagues and permanent employment. And unless the employer can show there are good reasons why this should not be the case. In other words, if the employer can give good reason for discrimination as between fixed-term employees and permanent employees, then this is the case that the employer has the right to discriminate between the two. Leave a comment below and let me know your thoughts about this state of affairs. So let us look at the way the contractual right occurs. The contractual rights are rights given by the employment contract, like I said, as opposed to those given by statute. Spoke about statutory and contractual rights, as I explained earlier. Statutory rights are more in giving of right to employee under these circumstances than contractual rights. That is the nature of statutes, which are primary source of laws enshrined by Parliament directly, affecting rights and obligations of individuals, in this case, employment. Examples of areas covered by contractual rights include the rates of pay above the national minimum wage, including overtime. Remember me talking about national minimum wage previously in the other videos, if you watch them. I've been mentioning the significance of the rate of pay in the United Kingdom, which is extremely important to me on this program, which began live as a program on the cost of living crisis. But employment, as I look at, my intention is also to illustrate condition of the cost of living, which I have also argued that under the employment system, including its laws and practices, the chronic problem at policy level and also at welfare level of the people in this country is the low level of pay, which keeps the British people in poverty. This is political more than a policy issue, which my invitation is for young people and the British people to approach their leaders, political leaders, to make sure this problem, chronic problem of poverty in the UK should be resolved one way or the other. So now we're looking back at law and policy. I'm discussing above the national minimum wage. As discussed in these objectives, we're looking at bonuses. We're looking at shift supplements. These are all elements of payments in terms of contractual rights, in terms of fixed-term employment, which we are talking about right now. So we're looking at company cars. Let us look at also contractual sick pay and sick leave, contractual maternity pay and leave, and parental leave, as we have mentioned again and again here as well as elsewhere. If you take note that at every element of our mentioning, there is repeatable points across all the elements, which you may or may not ignore, but this is the nature of policy or law. If you're a student of the same or similarly working within the profession in your professional capacity. So we're looking at categories: contractual maternity pay and leave, the parental leave. These are a contractual right, and these actually point to money or non-monetary benefits of employment, looking only the entitlement above the statutory minimum, pay, occupational pension, which is sometimes called work pension. If you work for a living, then you know that when you start a job, you start doing your work, you'll be given to pay a percentage toward your work pension, also known as a occupational pension, contractual redundancy pay and rights, career breaks and sabbaticals. If you take time of work by permission, by right, but be reminded that rights based on contract, there is a lot of discretionary undertaking by the employer. So the case often, generally, it's a general practice, as much as there are rights, there are discretionary component to this right, where in practice you are they do well to negotiate with your employer, because these rights are not automated, such as other right you might find with statutory obligation, statutory rights, which have been comparing with contractual right. Leave a comment below, stay tuned, continue watching. I'm so excited that you came. Thank you so much for participating in this program, and also if you have subscribed, continue sharing with family and friends. Be an ambassador and let me know what you thought about this program. This program has value in terms of informing people how the law of the United Kingdom operate in terms of contract and policy. In other words, in terms of work, which we actually are talking about. We're talking about work in the United Kingdom, but we are going deeper and deeper. As far as we can, leave a comment below. Let me know. We are talking about contract or fixed-term employee in terms of their rights. Therefore, you are talking about accessing training as of right in terms of the contract. Stay tuned, continue watching. So let us look at access to training as part of these contractual right. The regulation specifically stating that fixed-term employees should be given the same opportunity to receive training as permanent employees. So this is also indicating that such rights should be given without any reserved or unreserved discrimination. So unless the employer can show there to be good reasons why this should not be the case, this is meaning that the rights also given by the government in terms of regulation, it is actually watered down, is weaker than a statutory equivalence, where there is an obligation on the employer to provide such rights. Under this circumstance, there is a caveat in law within this contract where the employer can have discretion to decide to discriminate between fixed term or permanent employees if they have good reason. And the misfortune within law or policy is that nobody clearly understands what good reasons mean. And that means there is a lot of scope for abusing the law, and this law may, if it is to be strengthened for the purpose in favor of employee, should be statutorily enshrined in law to give more power to employee, to more rights. Rights is equivalent to employment power, if you want to look at it that way. So that is actually in terms of training, which are part of the elements I've been looking about. Listen, if you watch this video, if you struggle to follow this information within this video, try and visit gov.uk and the other website I've cited in the other videos, and leave a comment below if you specifically need some help. And thank you so much for participating, especially in giving feedback. Subscribe to this channel if you haven't subscribed, and if you have subscribed, thank you so much, and continue being a good ambassador as such. Therefore, looking at the various elements, and as we said, and therefore we look at opportunities to apply for permanent jobs in the organization in which you work. These are some of the rights. The regulations specifically state that a fixed-term employee must be offered the same rights as a permanent employee to apply for permanent jobs in the establishment where they work, unless the employer can show there to be good reasons why this should not be the case. Then we talk about employment opportunity, because individuals may start work at a fixed-term workers with less right, also with less employment uncertainty, with less certainty of employment. Then they may decide to upgrade their opportunities into permanent employment, but they may be discriminated against by the employer, and the law is not clear. It may be clear, but in practice, it doesn't give clear right to employee, because this is actually contractual right. It gives some discretion or substantial discretion to employee in terms of employment rights in favor of employees. If you are following this discussion, leave a comment below and let me know. And so we also look at the staff discounts, such as when there may be some offer. If you work, for example, in retail stores and you want to buy some good or service of some sort, you want to pay for a product, there might be staff discount on the pricing. And also you're looking at also staff access to share options. So when you talk about share, you talk about investing in an organization you work for. This is all employment rights. And in terms of fixed-term employment, so let's look at fixed-term employees, where they must also not be treated less favorably, as in being discriminated against by suffering any detriment from the employer. Detriment can include non-contractual benefits, such as fixed-term employees being paid smaller discretionary bonuses pro rata than permanent employees, unless the employer can show there good reason this should be the case. And we'll talk about discretionary powers given by the government according to this policy to employer, which is a direction of travel in terms of employment law generally. We give more power in the hands of employer, taking these powers away from the hands of employee. Like I've mentioned previously in the other videos in the opening chapters of this material. So let's look at who is the comparable permanent employee, as in comparable as in when a fixed term employee needs to compare their contractual rights to those of a permanent employee. The regulations give a definition of who counts as a comparable permanent employee. So we talk about comparability. An employee is a comparable a permanent employee if all the following apply. Is therefore applied or otherwise if it is not employed under a fixed term contract, is employed by the same employer as a fixed term employee, and also is engaged in the same and broadly similar work to the fixed term employee. We are looking at different elements where relevant as a broadly similar level of qualification, skills, and experience to the fixed term employee. Works at the same workplace as the fixed term employee, or if there is no permanent employee at that workplace, works at a different workplace, but still does the same or similar work to the fixed term employee and is still employed by the same employer. These are a listing of different categories of rights and sometimes obligation. And let's look at also fixed term employee cannot compare themselves to a hypothetical permanent employees. So hypothetical permanent employees are actually something which is theoretical, has to be in real terms. So in order to make a comparison, they must use an actual and permanent employee who fits the criteria above. Comparable rights to contractual sick pay, maternity pay, maternity leave, parental leave, and holiday entitlement. This is another a factor to be considered as to right. So the regulation specifically states that unless the different treatment can be justified on objective grounds, fixed-term employees must not be treated differently to permanent employees when giving certain contractual rights dependent on the length of service. So there are caveats of the length of service. But there is also a type of caveat which put a requirement of justified objectivity as ground for some form of discretionary power being given to employer in terms of this right, like we have said before. So for example, if an employer gives extra construction holiday to permanent employees but not to fixed-term employees, because all the permanent employees have worked there for more than 2 years, but none of the fixed-term employees have, this discrimination would only be justified if the employer could show objective reason why the employee has to have a work for 2 years before they are entitled to it. The problem with this type of law is that the objective reasonings may or may not be understood broadly in terms of certainty of law or policy, and there is a lot of gray area. There's a lot of ground given to employer to potentially actually take rights away from employee. This is unfavorable in my opinion. Leave a comment below. Let me know if you know anything or something about employment law or similar policy. So we are looking at fixed-term employee who must not be treated less favorably than a permanent employee with respect to, for example, the rate of contractual sick pay or maternity pay, the length of service required to qualify for payment, the length of time the payment is received, also contractual maternity leave, parental leave and contractual holiday entitlement must be given to fixed-term employee on a pro rata basis, so that to that given to permanent employees. So we'll talk about fair treatment or equal treatment between fixed-term and employee and also permanent employees. So fixed-term employees must be given the same access to this right as their permanent colleagues. For example, if the employer gives contractual holiday pay after 1 year's employment, this 1 year qualifying period will apply to both permanent and fixed-term employees. My comment on policy broadly is in terms of a qualifying period of time is that this is a bad law policy. And I invite the UK government to change this law as soon as they can, so that employee should have employment right initial. As soon as they become employee on day one, they should have full employment right. And in my opinion, complicating employment law is a way of watering down rights in favor of employee, which is something specifically designed to give more rights to employers who are already in the position of power. Therefore, there should be less, not more, contractually given discretionary rights to employer. We need more statutory rights which are more in favor of employee, or if any, also to employer, especially in the small and medium businesses, which actually structure of business may or may not need a substantial help in terms of financing, like grants to support them, but they should also be controlled by the government more, so that they provide good practice in terms of employing, in terms of paying employees, in terms of giving several rights, in terms of benefit of employment, like we have discussed consistently. So let us actually carry on and stay tuned, continue. So stay tuned, continue watching. Let us look at comparable rights to occupational pensions. These are rights of work or employment. For pensions, when you talk about pension, you're talking about people who have retired, who have reached retirement age. In terms of occupational pension, let us look at occupational pension schemes which must treat fixed-term employees in the same way as permanent employees. Remember, we are talking about employment status and rights which go with such types of contracts or statutory rights. So this is in respect of both rights of access to pension schemes, unless different treatment is justified on objective grounds. Also, it includes calculation of benefits under the pension scheme on a pro rata basis. We are looking at about employment rights, right of fixed-term employees in relation to occupational pension. Stay tuned. You can visit gov.uk or similar places for more details. Let's look at comparable right to contractual redundancy rights. We have already given in the other videos the elements of employment status and other aspects of rights and obligations, such as redundancy rights, for example, such as contractual redundancy rights, which is comparable to statutorily based redundancy rights. Redundancy, if you are made redundant, it means you are given certain benefit as of rights in terms of contract. So the contractual element of redundancy rights is what we're talking about here. In a contractual redundancy situation, Fixed-term employees should not be treated less favorably with regard to contractual redundancy right than comparable permanent employees unless the treatment can be justified on objective grounds. So once more, we are looking at the objectivity criteria which give discretionary opportunity to employer. Discretion in favor of employer means employer is getting more right in the relationship, in the contractual relationship between employer and employee, thereby employer having more rights within these arrangements. Often tend to disadvantage employee under this circumstance. So this means that, for example, the employee should have the same access to help and training to find alternative employment and the same contractual redundancy pay pro rata. Stay tuned, continue watching. So a fixed-term contract may include a waiver clause which prevents a fixed-term employee being entitled to statutory redundancy pay. So when you look at a waiver clause preventing a fixed-term employee being entitled to statutory redundancy pay, comparing the statutory redundancy pay and its waiver would amount to employee having less right of employment in terms of redundancy pay. This, in my opinion, is wrong because it disadvantages employees, especially if you are a fixed-term contractor. But also, it actually opens doors to other types of employment contracts. I have already said elsewhere that it is of necessity to strengthen employment law in terms of statute redundancy, statutory redundancy pay, as opposed to fixed-term contractual obligations. Such a waiver clause will only be effective if the contract was started, renewed, or extended before October 2002. So there are a lot of caveats in practice as to law, especially where laws are actually contractual based and where employment status is fixed term. Let us look what definition is given to a pro rata situation. So some contractual benefits of fixed-term employees should be calculated on a pro rata basis. This means that there are where a comparable permanent employee is entitled to receive pay or some other contractual right, a fixed-term employee is entitled to receive the proportion of pay or the right that is reasonable in the circumstances. This is a watering down of the law in favor of employer being given more rights. So bearing in mind also the length of contracts and the basis on which the pay or contractual right is offered. This is providing more complexity in terms of caveats, rights being given by one hand and also taken away by another in a subtle way in law. Some contractual based benefits may be offered to employees on an annual basis or over a specific period of time. For example, season tickets loan, health insurance, or staff discount card. These are weaker laws in favor of employee. Employee being at a situation where they lose rights, where a fixed-term employee is not expected to work for the entire period for which the benefit is offered. It may be appropriate to offer it in proportion to the duration of the contract. Once more, this is a type of watering down of the law in terms of right. So an employee on a 6-month fixed term contract may be offered a season ticket loan for 6 months. Or if their contract is for 4 months, they might be offered a loan for 4 months. There might be circumstances where it is not possible to offer the benefit in this way, in which case an employer may be able to justify not giving the benefit to a fixed-term employee. For example, if the cost of doing so would be disproportionate to the benefit the employee would receive. Now, this is a decision given to employer discretionary to decide whether or not to give such benefit. And these benefits are also loaned, which means they should be paid back. This is bad policy, in my opinion. It's a type of policy you find within the marketized system of the economy of employment, which is what I have been talking about. Also, we will going back to talk about such things going forward. So we are still looking at these specifics. When can an employer treat a fixed-term employee less favorably? Regulations state that a fixed-term employee should not be discriminated against similarly simply because they are a fixed-term employee, unless the different treatment can be justified on some objective grounds. This means that the employer can only treat a fixed-term employee differently to a comparable permanent employee if they have another valid reason for doing so, which is nothing to do with the fact that the employee works on a fixed-term contract. Now, this is a complicated outlook of law, which is not clear and certainly unhelpful in moment of dispute. It should not be possible for an employer to claim that there is a blanket valid reason for treating all their fixed-term employees less favorably than their comparable permanent employees. Now, anybody can interpret this kind of regulation any way they like, and in my opinion, they are a failure of policy and law. If we want to argue at policy and politics for laws to give more strength and rights to employee. So let's look at how the comparison is made between a fixed-term employee and a permanent employee. So when comparing a fixed-term employee with a permanent employee, an employer may seek to show that although certain individual terms of the fixed-term employee's contract are not as good as those of a permanent employee, by the term approach, the term-by-term approach, taken as a whole, the contractual rights of the fixed-term employee are as favorable as those of permanent employee. The package approach. So, for example, a fixed-term employee may argue that their rights to contractual holiday and sick pay are not as good as those of a permanent employee. So the employer may seek to justify this difference by showing that overall, the fixed-term employee is on a higher basic rate or pay to compensate for having less contractual holiday and sick pay. So these are actually the justificational point where discrimination occurs. Leave a comment below what you think about this situation. So it is likely that how such comparisons are made will be an area of contention for fixed-term and permanent employees. Employment tribunals will have to determine how the overall comparison will be made. If a fixed-term employee considers that their employer might have treated them less favorably than a permanent employee, they can ask their employer for a written statement of the reason for the less favorable treatment. The employer must provide a statement within 21 days of the request. Let us also look at what might be objective grounds for less favorable treatment. We have discussed this above with caveats as it could show to demonstrate how and by law the government may give more rights to employer as opposed to more rights to employee. So there is no definition of objective grounds that may be used to justify an employer refusing to give fixed-term employees the same contractual rights as a permanent employee. Like I said before, this is an area of lacuna in terms of law, where laws are set in contractual terms to give more discretionary power to employer in disfavor of the employee. So until cases have been taken to employment tribunals, it won't be clear what might constitute objective ground. I've made this point above. So leave a comment below and let me know the state of affairs pertaining to this condition given under the contractual law as to how employer treats their employee in terms of fixed-term contract. So the Court of Appeal has decided that the non-renewal of a fixed-term contract cannot in itself constitute less favorable treatment because it is of the essence of such a contract that it comes to an end at the end of the fixed term, at the end of the fixed term. So let us look at rights to receive a written statement of reason for less favorable treatment. Stay tuned, continue watching. Thank you so much. So if a fixed-term employee considers their employer might have treated them less favorably than a permanent employee, they can ask their employer for a written statement for the reason for the less favorable treatment. So the employer must provide a statement within 21 days of the request. Thank you so much. Continue watching. Stay tuned. Leave a comment below in terms of these laws and policies. So if the fixed-term employee takes a case to an employment tribunal about the less favorable treatment, the tribunal may take into account whether the employer has complied with any request for a written statement or has provided a written statement which is evasive about the reasons for the less favorable treatment. Stay tuned, continue watching. Thank you so much. So if the fixed-term employee has been dismissed and is entitled to a written statement of reasons for dismissal, the above paragraphs do not apply. They should, however, request written reason for dismissal. They should not be dismissed or suffer a detriment as a result of asking for a written statement of reason or less favorable treatment. Thank you so much. Continue watching. You can visit gov.uk to look into more detail about who is entitled to written reason for dismissal. Thank you so much. Let's also look at how a fixed-term employee can enforce their rights. So negotiating with an employer and raising a grievance as well. If a fixed-term employee believes that they are being treated less favorably than a comparable permanent employee, they can try to negotiate with the employer. So the client will often need someone else, for example, certain organizations such as Citizen Advice, to negotiate on their behalf. So let's look at the fixed-term employee whose complaint is that they are being discriminated against because they have a fixed-term contract and is not obliged to raise a grievance before making a claim to an employment tribunal. However, they should raise a grievance if there is time within the time limit for making a tribunal claim. Continue watching, stay tuned. Thank you so much. This is because raising a grievance is a sensible way of addressing problems that have arisen. An unreasonable failure to raise a grievance when the employee could have done so may result in any tribunal award being reduced. If formal negotiations within the employer are unsuccessful and the employee is not satisfied with the outcome of a grievance procedure, they can enforce their rights through an employment tribunal. You can visit government website and similar website to look into more detail about how to negotiate with an employer about raising a grievance as well. So looking back, enforcing rights through an employment tribunal. So you must notify ACAS of your potential claim before you can make a claim to an employment tribunal. The early conciliation procedure applies to most employment tribunal claims and will affect the time limit for those claims. We are talking about early conciliation. Visit gov.uk and the relevant website. Thank you so much. Stay tuned. Continue watching. Looking at a fixed-term employee believing they are being treated less favorably than a permanent employee, they can go to an employment tribunal. They should raise a grievance first if there is time to do so within the time limit to make a claim. An employment tribunal claim must be made within 3 months of the date of the less favorable treatment, 6 months for members of the armed forces. If the fixed-term employee has been treated less favorably on a number of occasions, which are part of a series of acts, the time limits may run from the date of the last such occasion. In a case concerning a non-contractual bonus paid only to permanent employees, the Employment Appeal Tribunal held that the date of the act or complaint of was the date the employer announced the details of the bonus to relevant employees rather than the date they decided against paying the bonus to fixed-term employees. Leave a comment below. Thank you so much. These information sound repeatable, and they are, but because we are talking about fixed-term employee as opposed to other types of employment statuses, you can look more to study about time limits and a series of continuing acts. So an employment tribunal can award compensation to a fixed-term employee who has received less favorable treatment. The tribunal can also make recommendation to what action an employer should take, for example, by providing a part-time employees with a new written statement of terms and conditions. A tribunal may award compensation to an employee if the employer does not comply with the tribunal's recommendations. Thank you so much. Continue watching. Stay tuned. We are looking at employment law. We are looking at work. We are looking at specific employment status in terms of contract and also the rights of employment in relation to such contracts. So there is no age limit for making a claim under the regulations, and the employee does not have worked for the employer for any particular length of time before they can make a claim. So you can look more about making a claim to an employment tribunal. Employee, when he suffers a detriment or is dismissed for trying to enforce their rights under the regulations, stay tuned, continue watching. Since the 6th of April 2014, the early conciliation process applies to most employment tribunal claims. This affects the time limit for making a claim. You can make a further study about early conciliation process and also about the effect of early conciliation on time limits. If a fixed-term employee tries to enforce their rights as set out in the regulations, they can make a claim to an employment tribunal. The time limit for taking a case to an employment tribunal is 3 months from the date of the act complained about. Stay tuned, continue watching. If an employee is dismissed for trying to enforce a statutory right, this is an automatic unfair dismissal regardless of how long they have worked for the employer, and they can therefore make a claim to an employment tribunal. If the employee has been dismissed, the time limit for taking a case to an employment tribunal is 3 months from the effective date of termination. An employer should have a dismissal procedure and follow this when dismissing the employee. You can do further studies about the effective date of termination or about dismissal procedures. There is no time limit for making a claim under the regulations, and the employee doesn't have to have worked for their employer for any particular length of time before they can make a claim. Stay tuned, continue watching. Thank you so much. Let us look at the situation of discrimination. Discrimination is for fixed-term employees and also discrimination within this employment status. There might be an imbalance in the proportion of a particular group of staff who are fixed-term employees rather than permanent employees. This might be the case if, for example, nearly all the fixed-term employees are women and nearly all the permanent employees are men, or vice versa. Leave a comment below, let me know what you think. Thank you so much if you have been watching up to this end. Share with family and friends. Also leave a comment below, let us have a conversation in terms of this law and policy. Subscribe to my YouTube channel if you haven't subscribed already. And click like and click notification bell. Thank you so much. We are looking at fixed-term employee status and employment and the rights attending to the same. So a fixed-term employee might be able to take a case under discrimination law if they believe that they have the followings. If they have been treated less favorably than a permanent employee, been dismissed or suffered detriment for enforcing their statutory rights. You can look further about identifying discrimination. So if the employer tries to give worse terms and conditions for permanent employees. So we are looking now at permanent employees in terms of contracts and their rights. Therefore, continue watching, please. Thank you so much. It is possible, therefore, that an employer will try to give poor terms and conditions to their permanent employees rather than improving terms and conditions of fixed-term employees. So advantage to employees can be revised downward, watering the value down other than up. This means the employer will be able to claim they have treated fixed-term and permanent staff equally. This is kind of like another lacuna in the law, which employer can exploit to their advantage. However, if an employer does attempt to reduce the terms and conditions of a permanent employee in this way, without the employee's voluntary agreement, the employer will have breached the contract between the employer and the employee. We're talking about breach of contract of employment. So if an employer is attempting to reduce the terms and conditions of their employees, you will need to negotiate with the employer. Negotiation is a tricky governor, because you see, you negotiate with somebody if there is a balance, a proportionate balance of power. Under these circumstances, the policy, in my opinion, is wrong, because employee normally, when negotiating with the employer, the outcome is always detrimental to the employee. So let's look at a situation where an employee may wish to consider taking a claim to an employment tribunal or a court for breach of contract for unlawful deduction from pay or constructive dismissions. We have already discussed these terminologies, these concepts in the other videos. Leave a comment below and let me know your thoughts. You can do a deeper study about what a client can do if their employer is trying to change their employment contract, or also about how to negotiate. Thank you so much. Continue watching. Let's look at employees' rights on the ending of a fixed term contract. So when you are in this situation and there has been and the worker has been, the employer has been working on a fixed term contract, it is always essential to see a copy of the contract. So a fixed term contract is the same as any other contract of employment in all respects, except that the law treats its ending differently. In practice, where a client has a problem with a fixed term contract, the problem will most commonly be about ending of the contract. As with all other employment contracts, an employee with a fixed term contract has certain statutory rights, and an employer cannot make them agree to contract terms which are inferior to these rights. I've already mentioned above the difference between statutory and contractual rights in law. So now, therefore, it used to be the case that fixed-term contracts could contain a term which attempted to deny the employee any right to claim either unfair dismissal or redundancy. These were known as waiver terms or clauses. For fixed-term contracts, which started on or after the 25th of October 1999, waiver terms which try to limit claims for unfair dismissal are invalid. There are special rules for waiver clauses and redundancy. This is pointed to failure at policy in terms of actually providing negligence at law by the government, which is responsible for setting laws, which a situation takes away from employee in terms of right at law. So let us look at whether or not an employee end of a fixed if an employee can end a fixed term contract early. An employee can end a fixed term contract early if the contract allows for this. The employee will be expected to give a certain amount of notice which will be specified in the contract. If you want to know more about how much notice an employee must give an employer, you can visit the website and do a study. Leave a comment below and let me know. So if the fixed term contract does not allow the employee to end the contract early, an employee will technically be in breach of contract if they do this. However, although the employer could bring a claim against the employee for breach of contract, the employer would not be entitled to damages unless they could show that the employee's actions had caused the employer to suffer a financial loss. So let's look at an employee being dismissed before the end of the fixed contract terms. Continue watching. Thank you so much. So in this situation, a client who has been dismissed before the end of a fixed term contract, under these circumstances, it's necessary to check the contract to see if it allows the employer to dismiss them. The dismissal will be allowed if the contract contains a term allowing the employer to terminate it early by giving notice. If the contract does not include such a term, the dismissal will be in breach of contract unless the client has been dismissed for gross misconduct. So when dismissing an employee on a fixed term contract during the period of the contract, the employer should follow a dismissal procedure. If you want to know more on the dismissal procedure of an employer should follow. You can visit gov.uk or the similar websites. If there is no termination clause, the client is dismissed for reasons other than gross misconduct. They will be able to claim damages for the remainder of the contract. For example, if the contract was for a fixed term of 3 years and the client was dismissed after 2, the client will be able to sue the employer for a year's salary and any fringe benefit that they have lost. However, if the client has subsequently found another job, their actual or estimated net earnings received from the new job will be taken into account when calculating any compensation awarded. Leave a comment below under these circumstances. Let me know what you are thinking. You can find out more on suing an employer for breach of contract. So where a client is dismissed before the end of the fixed term, any waiver term in their contract to prevent them from claiming a redundancy payment won't apply. This means that if the client meets the qualifying conditions, they will be able to claim a redundancy payment. Waiver terms for redundancy payment are being phased out. So if the client qualifies to claim unfair dismissal and redundancy payment, they can claim both. You can find out more about qualifying conditions and claiming unfair dismissal, also about the qualifying condition and claiming redundancy payment. Thank you so much for watching. Continue.
MVC record.
Bravo, Jesus on the beat.
Thank you so much. We have been looking at work in the United Kingdom, at law and policy. Watch this video and the rest of the video. If you watched this far, thank you so much. You're a champion. Subscribe to my YouTube channel if you haven't subscribed. Click notification bell and click like. Share the video with family and friends. Employment in the United Kingdom or elsewhere in the world is important because it is a primary source of income. So when we begin to talk about work, which is under employment, we are talking about elements including employment and workership, or others like like apprenticeship. And we are also shown today how you can make claim within rights of employment in terms of contract and also statutory obligations or rights. Thank you so much, and continue watching. Going forward, watch the rest of the video also alongside with this. Work, like I said, is essential because it's a fundamental element to income. Income is what you get when you work in the United Kingdom, but also what you get when you claim benefit, as in welfare state benefit. But we have also seen within employment itself, there are different types of benefit, including pay, including the rest of the other non-payable or non-paid or non-monetary payment or rewards. And leave a comment below, let me know what you think. And this is part of part of looking at income and also the welfare component of employment. But employment also is part of development in terms of progress. So leave a comment below, let me know about these laws which we have discussed. Going forward, we will be looking at affairs more specifics, and then take time off and do a review of what we have been learning. Thank you so much. See you in the next video. Subscribe to my YouTube channel. Thank you so much. Bye bye.
Quiero